As I mentioned, we proceed now to Delaware, and David Millon will now take the floor, and welcome, Planet, also. So we are now ready. So, David, please.
I'm going to go ahead and start talking while people are making their way back into the hall. First, I want to thank Beata and Mona for fantastic organizational work they've done for this conference. Great honor for me to be part of this project, and great honor for me to have the opportunity to speak to you all here today. My focus is on U.S. company law, which means Delaware company law. As you all know, state law governs, for the most part, governs business corporations in the U.S., and Delaware is the most important state for that purpose. Over 2/3 of the largest U.S. companies are incorporated in Delaware, and you don't have to have any actual physical presence in the state in order to do that. So Delaware law, of course, is hugely important as far as the issues we're concerned with here are. Before I want to make two key points, and I'm really echoing points that have been made earlier, but I want to make sure everybody understands what the U.S. Situation is with respect to these matters. Two key points. First, that Delaware law does not require or mandate shareholder primacy, and second, that even though that's the case, Delaware companies, U.S. companies generally, behave as if it does. And then I will discuss briefly a couple of law reform possibilities to address sustainability values, and then if there's time left, I'll talk a little bit about why there's very little hope that anything I'm advocating here is going to happen anytime soon. But I am grateful to Beata, because I tend, at my age, advanced age, I get increasingly cynical about all of this stuff, and she's been very good about propping me up and encouraging me to be bold in my thinking and try to be positive. So I'm going to try to do that, even though it's hard. First key point then is that Delaware law does not mandate the shareholder primacy conception of corporate purpose or management responsibility. That is, I think, a fairly obvious point, although it's not widely accepted within U.S. academic company law circles. Mainstream corporate law academics in the U.S. continue to insist, or at least claim, that company law is about shareholders primarily. But if you look for a legal authority for that claim, you can't find it. The Delaware statute says nothing at all to that effect about corporate purpose or about management's responsibility being primarily to the shareholders. Neither statute nor does case law say anything of that sort. And if you look at the ability, the legal tools that Delaware law puts at the disposal of shareholders to insist on their interests, they're very weak. The shareholder derivative suit is a very ineffective enforcement mechanism. Shareholder voting rights have very little practical purpose in the big public companies. And the hostile takeover, unlike UK law or EU law, is not a really very viable mechanism for holding management accountable to shareholders, because the Delaware judges have given management very broad power, almost unlimited power, to defend against unwelcome hostile takeovers, which is a good thing. So Delaware law does not mandate shareholder primacy, which means that as far as Delaware law is concerned, it would be possible for management to take into account a wide range of non-shareholder considerations, including environmental ones. Second key point, though, is that they tend not to do that. Neither Delaware companies nor other U.S. companies take advantage of the space in the law that would allow them to pursue non-shareholder values, environmental sustainability among them. Instead, they behave as if shareholder primacy is the law. Now, why is that? We talk in the paper that Andrew spoke about, the paper that Beata and Andrew and I have been working on, about shareholder primacy as a social norm, a sort of ideological construct that structures the way people think about appropriate behavior, and it certainly is that. But there are much more concrete reasons, I think, that explain why U.S. companies pursue shareholder value so relentlessly. And by the way, by shareholder value, we mean very short-term conception of shareholder value, basically current share price as measured by quarterly accounting results. Now, why? Sure, the ideology or the norm is part of it, but management incentives drive a lot of this. They are compensated by stock options, typically, or outright stock grants. They also earn strong reputational payoffs from a strong record of share price performance at their company. So in the market for corporate executives, there are significant incentives for maximizing current share value. Second, institutional shareholders who, as a class, own about 3/4 of the stock of the largest U.S. companies now, 3/4, generally insist on short-term share price maximization. And there are important reasons for this that I think are not widely understood. The public pension funds in the U.S., some of which are massive, have obligations to their beneficiaries that must be met on a monthly basis. They have to produce cash and pay and write checks to retirees on a monthly basis. And even though pension funds have to take a long-term perspective in the sense that they're going to have obligations to retirees that extend far into the future, the current demands are strong. And this means that they do not have the luxury of taking or feel that they don't have the luxury of taking a long-term view. They've got to have current returns. And if companies don't generate current returns, the pension funds will sell their shares. The effect on the share price will be negative. Managers face sanctions for that, not just reputational ones, but they can lose their jobs. Not just the pension funds, but also the mutual funds most of the large mutual funds also put strong pressures on management to maximize current share value. And this is because mutual funds earn their fees based on the total value of the assets under management. So they're competing for investor dollars. Investors, in the U.S. at least, are interested primarily in quarterly or at least annual returns. And so the mutual funds are also putting pressure on corporate management to generate strong quarterly bottom line and maximize current share price. And what this means, this is important, I think it's obvious, but it's important, is that companies are very reluctant, U.S. companies are very reluctant to spend money on things that do not generate immediate value. So long-term payoffs are a luxury that they feel they can't afford. This has implications for sustainability, it has implications for other CSR-type initiatives, it has implications for research and development, advertising, all kinds of expenses that have an immediate impact on quarterly accounting results, but generate offsetting benefits only in future accounting periods. So there's an important accounting issue here. Now, okay, so Delaware law doesn't require shareholder primacy, but corporations behave as if it does. So law does have a role to play here in changing corporate behavior, and I want to talk about two possible law reform initiatives, the first of which I think is not as promising as it might at first appear. And the first would be for Delaware to enact a so-called Constituency Statute. 41 of the 50 states have these already, but not Delaware. The basic idea behind these constituency statutes, and they vary in detail, but they're all essentially the same. Now, the constituency statutes authorize management expressly to consider a range of non-shareholder values, of stakeholder values, and these are typically listed in the statute. And so there'll be reference to employees, to local communities, to creditors, to consumers, and the like. And unlike Section 172 of the UK Company Act, these statutes, by implication or even expressly, say that management is not required to prioritize shareholder value in any sense of the term. That's the whole purpose of these statutes. So they sound as if, although none of them at the moment actually mentions sustainability, but I think by implication they all would allow it. A Delaware statute, if one were to be enacted, would need to say that expressly. But the big problem with these statutes is that they are merely permissive. Well, one of the big problems, that's the primary one. There are others as well. They're merely permissive. They authorize management to take these non-shareholder values into consideration. Time just sped up. It's scary how that happens sometimes. Let me just close. On the constituency statute, closure on that. They're merely permissive, so they're not going to be strong enough. They're not going to provide a strong enough counterweight to these other incentives that encourage management to pursue short-term shareholder value. So what is needed is probably a mandatory, a requirement that corporate management take into account sustainability if we really expect change to happen in that direction. Some, I think, fairly challenging technological issues involved in drafting a statute like that, but they're not insurmountable. Enforcement, I think Andrew talked about this earlier, is important. And also, there needs to be some transparency so that concerned stakeholders know what companies are doing with respect to their impacts on the environment. So those two technological challenges are important, but by no means insurmountable. Now, finally, is any of this likely to happen? I don't want to, well, I'm not any more encouraged than Andrew is about this. In fact, it's worse because we're not part of the EU. There's nobody really going to tell us to do this if we don't want to do it. And there are a lot of reasons why I think it's unlikely that this would happen. In the U.S. right now, as has always been the case, capital calls the shots, and the U.S. Supreme Court is in the process of trying to make it easier for big corporations to do that. That's the point of the Citizens United decision, which gives companies more power to influence the political process than they already had, and they already had a lot. The Delaware legislature, Delaware judiciary is quite conservative. One of the strengths of Delaware law is that it's very stable, it doesn't change much over time, so any kind of significant law reform is inherently going to be met with skepticism. Many people would say reform is not necessary. You don't need to reform company law to do this because external regulation in the form of environmental law is the way to go if you're concerned about environmental values, labor law, similarly, and the like. So I see my time is up, and thank you. Okay.